Hi, I'm Chadwick Schnee, a Pennsylvania attorney. In my last video, I talked about cease and desist letters, what they are, and how to respond if you receive one. I mentioned that Pennsylvania has a new law that can be a powerful tool if someone is using litigation to try to silence you. Today, I want to go deep on that law. In July 2024, Pennsylvania enacted the Uniform Public Expression Protection Act, also known as Act 72 of 2024. It is Pennsylvania's most significant anti-SLAPP law to date, and it has real teeth. I have used it in active litigation, and I want to explain what it does, who it protects, and why it matters. What is a SLAPP? SLAPP stands for Strategic Lawsuit Against Public Participation. The idea behind a SLAPP is not to win in court. The lawsuit itself is the weapon. Here is how it works. Someone speaks out. Maybe they criticize a developer at a public hearing. Maybe they write about a local official's conduct. Maybe they post on social media about a business dispute. Maybe they run a community newsletter that covers local government. And then, instead of engaging with the criticism, the target files a lawsuit. Defamation, invasion of privacy. Tortious interference. The specific claim matters less than the effect. The defendant now has to hire a lawyer, sit through depositions, respond to discovery requests, and spend months or years defending a case, even if the underlying legal claim is completely meritless. By the time the case gets dismissed, the damage is done. The defendant has spent thousands of dollars and enormous amounts of time. And the message to everyone watching is clear: speak up, and this could happen to you. That chilling effect on public participation is exactly what SLAPPs are designed to produce. Pennsylvania lawmakers recognize this problem directly in the text of Act 72, calling it a disturbing increase in lawsuits brought primarily to chill valid public expression. Pennsylvania's old anti-SLAPP law was practically useless. Before Act 72, Pennsylvania had an anti-SLAPP statute, but it was so narrow it almost did not matter. It only protected people petitioning the government about environmental issues. It did not cover online speech. It did not cover journalism. It did not cover showing up to a public meeting and asking a question. For the vast majority of situations where SLAPPs actually happened, Pennsylvania offered almost no protection. That made Pennsylvania a comparatively attractive jurisdiction for SLAPP plaintiffs. They could file meritless claims here with less risk of early dismissal than in states with stronger laws. Act 72 changes that fundamentally. What Act 72 actually does, the core of Act 72, is its definition of protected public expression. The law defines this broadly to cover communications made in connection with government proceedings, communications about issues under consideration in those proceedings, and any communication on a matter of public concern. That definition is wide by design. It covers the speech that SLAPPs most frequently target. The substantive portion of the law, which took effect the day Governor Shapiro signed it, provides immunity from civil liability for claims based on protected public expression. And critically, this is not just a state court protection. Because the immunity is framed as a substantive right rather than a procedural rule, it applies in federal court as well. That is a significant improvement over many other states' anti-SLAPP laws, which federal courts have sometimes declined to apply. The fee-shifting provision is where the law gets real teeth. If you raise this immunity and prevail, the party that brought the meritless claim against you has to pay your attorney's fees, your court costs, and your other litigation expenses. That provision applies in both state and federal court. It completely changes the risk calculation for anyone considering filing a SLAPP suit in Pennsylvania. The procedural provisions are still pending. I want to be transparent about something. Act 72 also includes procedural provisions that would make the law even more powerful. A special motion to dismiss that a defendant could file within 60 days of being served, a requirement that the court hear argument within 60 days of the motion, and an automatic stay on all discovery while the motion is pending. Those provisions have not yet taken effect. The Pennsylvania Constitution gives the Supreme Court exclusive authority over court procedures, so those provisions cannot take effect until the Supreme Court promulgates consistent rules or gives the legislature a green light. As of now, the Supreme Court has not done that. Free speech advocates, journalists, and legal organizations are actively urging the court to act. Even without the procedural provisions, though, the substantive immunity and the fee shifting are in effect today and available to be raised in existing litigation. The Slapback Act 72 also includes what is called a slapback provision. If you prevail in defending a SLAPP suit, but the court does not formally rule on your immunity under Act 72, you have the option to file a new civil action specifically to recover your attorney's fees and costs from the party that sued you. It is an additional accountability mechanism and a further deterrent against abusive litigation. Who does this law protect? The protections are broad. They cover individual citizens who speak at public meetings or write about matters of public concern. They cover journalists and news organizations. They cover nonprofit organizations and advocacy groups. They cover community members who participate in government proceedings. They cover defendants in defamation actions who were targeted for their public expression. The law passed both chambers of the Pennsylvania legislature unanimously. That is not an accident. The coalition that supported it included press freedom advocates, civil libertarians, government transparency groups, and business organizations. The problem of SLAPP suits crosses ideological lines, and so did the support for fixing it. Real results, our Clearfield County victory. This is not just theory for our firm. We have already used Act 72 in active litigation to protect clients facing meritless claims targeting their protected speech. In a matter in Clearfield County, Pennsylvania, we successfully invoked Act 72 on behalf of a client who had been sued in an effort to silence their public expression. The court agreed with our position, and we obtained an award of over $6,000 in attorney's fees, court costs, and litigation expenses on our client's behalf. The law works, and we know how to use it. We are also arguing in ongoing litigation that Act 72 bars injunctive relief against parties exercising their rights under Pennsylvania's right-to-know law, which would be a significant extension of the law's protections into the open government context. What you should do if you are being slapped, if you have been sued or threatened with a lawsuit because of something you said, wrote, or communicated about a matter of public concern. Here is the bottom line. Do not assume you are without a defense. Act 72 may provide you with immunity, a path to dismissal, and a mechanism to recover your legal fees from the party that brought the meritless claim against you. The law is still relatively new. Its full scope is being developed through ongoing litigation. Having an attorney who is familiar with the statute and is actively litigating under it makes a real difference. If you are a journalist, a community activist, a nonprofit, a blogger, or simply someone who spoke up about something that matters and got sued for it, reach out to Schnee Legal Services. You can find us at schneelegal.com. Thanks for watching.